In 1787, the founders crafted 7 articles to rescue a fractured America. Articles meant to divide power, prevent tyranny, and hold the nation together. Today, presidential immunity rulings, constitutional showdowns over federal funding, and states openly defying federal law have pushed those original safeguards to the brink. If the core protections of the 7 articles were designed to stop chaos, wider headlines now echo the very crises they were meant to erase. Some say we're closer to crisis than ever before. What happens if the Constitution's oldest pillars finally give way? The answer begins with the story you were never taught. In the summer of 1787, the delegates gathered in Philadelphia faced a nation on the edge. The Articles of Confederation had left Congress powerless, unable to tax, unable to settle disputes, unable to hold the states together. James Madison and Alexander Hamilton, restless and wary, saw chaos looming if something wasn't done. Madison pressed for a strong legislature, warning that unchecked ambition would tear the country apart. Hamilton, never one to mince words, called the old government a recipe for anarchy and demanded a more forceful executive. Across the hall, delegates like William Paterson pushed back, insisting that state sovereignty must survive in any new system. The result was a document built on compromise, but haunted by mistrust. Article 7, the final article, set a bold requirement. The new constitution would become law only after 9 out of 13 states agreed. No more endless waiting for unanimous consent. The stakes were real. If enough states refused, the Union could splinter for good. As New Hampshire became the 9th state to ratify in June 1788, the Constitution crossed the threshold, but not without bruising battles in state conventions and fierce opposition from anti-federalists. The promise of a Bill of Rights became the price for consensus, a pledge made to win over skeptics who feared unchecked federal power. The urgency and fragility of that moment echo in every debate over the Constitution's meaning today. What happens when the rules meant to bind a nation are themselves up for debate? James Madison believed that government power must be divided, not just shared. Ambition must be made to counteract ambition, he wrote in Federalist 51, capturing the spirit behind the Constitution's first 3 articles. Article 1 hands Congress the power to write laws and control the nation's finances, the so-called power of the purse. No money leaves the Treasury unless Congress says so. Article 2 gives the President the duty to enforce those laws, but not to spend at will. Article 3 creates a federal judiciary designed to interpret the rules and settle disputes, but with limits. Judges don't command armies or set budgets. Each branch is armed with its own tools and its own guardrails. Madison pictured a system where each branch would keep the others in check, not out of trust, but out of necessity. The legislative branch could fund or defund, the executive could veto or enforce, and the courts could judge the boundaries. This blueprint wasn't about harmony, it was about engineered tension. When one branch overreaches, the others are supposed to pull it back. Today, every controversy over spending, executive orders, or judicial rulings traces back to these original lines in the sand. Are those boundaries still holding, or are they being washed away by modern politics? In Washington, the battle lines are drawn sharper than ever. Congress, armed with the power of the purse since 1787, finds its authority tested with each passing year. The Impoundment Control Act of 1974 was meant to settle the matter. After Nixon froze billions in funds, Congress demanded that no president could hold back money it had appropriated. But the struggle didn't end there. In the past 2 years alone, federal courts have issued more than a dozen injunctions against the executive branch for withholding or redirecting funds, echoing the very fights the founders tried to prevent. In 2024, The Supreme Court's ruling in Trump versus United States granted broad immunity to presidents for official acts, dividing the justices and the public. The majority insisted this shield is essential for a functioning executive. The dissent warned it risks turning the president into a figure above the law. Meanwhile, Congress debates bills to rein in nationwide injunctions, wary that single judges can block entire federal policies. Each branch claims to defend the Constitution, yet their collisions reveal a system straining under the weight of its own checks and balances. If ambition was meant to counteract ambition, what happens when ambition refuses to yield? In state capitals from Austin to Boise, governors and lawmakers are pushing the boundaries of the Constitution's promise of unity. Texas's SB 4, signed into law in March 2024, gave state police the power to arrest anyone suspected of crossing the border illegally, a direct challenge to the federal government's exclusive authority over immigration. The Justice Department sued, and federal courts halted the law, citing the Supremacy Clause in Article 6. But the message was clear. States are willing to test the limits of federal power, even as the Supreme Court warns that immigration policy belongs to Washington, not the states. The tension isn't just about borders. Idaho's law criminalizing those who help minors travel out of state for abortion care has sparked lawsuits over whether states can punish actions that are legal elsewhere. Missouri's refusal to enforce federal gun laws and threats against local officials who do have already been struck down by federal courts. Each of these battles calls into question whether the full faith and credit and privileges and immunities clauses of Article 4 still hold. Meanwhile, the push for a convention of states has reached new heights. 19 states have formally petitioned Congress to call an Article 5 convention, and activists warn that if the threshold is met, the Constitution itself could be rewritten. As interstate lawsuits pile up and state defiance grows, the very idea of a single supreme law hangs in the balance. How much longer can the center hold? In 1787, the framers adopted 7 articles to replace a failing system and anchor a new nation. Today, as of 2024, 19 states have formally called for an Article 5 convention, and federal courts have issued more than 30 nationwide injunctions in the past year alone. Recent Supreme Court rulings, including Trump versus United States, have tested the limits of executive immunity, while state actions like Texas SB 4 challenge federal supremacy under Article 6. What remains unclear is how far these constitutional fault lines can stretch before the framework must adapt. Many founding debates over legislative power, executive limits, and state sovereignty still shape national conflict. The original text endures, but its interpretation is contested at the highest levels. As James Madison wrote in Federalist 51, ambition must be made to counteract ambition. The 7 articles were designed for balance. Whether that balance can survive today's pressures is a question still being answered.